Are you offered a plea deal in your case? Well, don't sign anything until you know for sure what it means. Hi everyone, Attorney Joe McPeak with Virtuoso Criminal and DUI Lawyers. In this video, I'm going to discuss generally, emphasis generally, what it means to accept a plea deal or think about whether or not to accept it. Full disclosure, this video is not going to tell you if you have a plea deal on the table. This video is not going to tell you whether or not you should actually accept that plea deal. That's really not something that anyone can give a straight answer to unless they've actually done the work on the case and found out what strengths and weaknesses are in a given case and whether or not that plea deal is really worth it, as we say. So I'm going to talk more here about the general analysis that goes into whether or not a plea deal is a good idea. Even if I can't specifically answer a question whether plea deal X or plea deal Y is a good option, I'm going to talk very honestly about what I do when I go through whether or not my client should accept a plea deal. A plea deal is an agreement where you plead guilty or no contest in exchange for a reduced charge or sentence, or sometimes both. It could end your case faster, but there are some trade-offs. The pros of a plea deal is that it usually can result in a shorter sentence or probation instead of incarceration or jail time. It avoids the risks of trial. Usually if you go to trial and you lose, your sentence is totally up to the judge who you're in front of. And that sentence may be worse than what you could get by negotiating a plea deal. The rationale is that once you've gone through trial, the judge has heard all of the facts of the case after the jury has found you guilty, and it's totally up to them how serious or how lenient they want to be. And you're taking that risk when you don't accept the plea deal, instead go to trial. You also use plea bargaining to change the charges. Maybe a strike felony becomes a non-strike. Maybe you have immigration considerations, and by plea bargaining, you can get the DA to agree to change certain charges to something that is immigration safe, for example. If you're charged with drug trafficking, maybe the DA is willing to agree to reduce it to what's called Penal Code 32, accessory after the fact. If you're charged with DUI, maybe reduce it to wet reckless instead, something very valuable to our clients who are on certain types of immigration status, including deferred action of child of arrivals, or DACA. Certain firearms offenses can be changed as well. I can go on. Plea bargaining can accomplish all of these things in ways that going to trial might not be able to accomplish. Granted, if you go to trial and you win, you get a not guilty, and that's a great result. But if you don't get that result and you get found guilty, you're stuck with all the negatives that come with the charges that you were facing originally and the risks of you don't know what sentence the judge is going to give you. It could be worse than what you could have negotiated. Now, there are some risks to accepting a plea. You give up your right to have a trial, and take the chance of getting found not guilty. A conviction stays on your record, and this could impact your job prospects, or maybe even other cases that you're currently fighting. It could have an impact on how you look there. What you should do first is have a lawyer review your case and the plea deal and the evidence they're claiming against you. And you and your lawyer should ask, is this really the best offer, or can we fight for better? One thing that I always ask is, if my client rejects this deal and goes to trial instead, what are they realistically facing? I had, for example, a very serious assault case that my client was facing one time, and it came with a lot of different negative consequences. And basically the DA's offer, came with a significant period of jail time, a lot of collateral consequences. They wouldn't also change the charge. It carried immigration problems too. And they just weren't giving my client any benefit. And the amount of jail time they wanted, I thought, this looks the same or similar to what my client gets if he were to go to trial. It's like the DA wasn't giving my client any credit for waiving his right to a trial. That client, for example, didn't really have that much of a risk seeing the judge after getting found guilty after trial, because the deal he was being offered felt very similar. It was a case where really the odds were stacked against our client, and the DA maybe knew it, but they really took advantage of him. And as a result, we fought back. We did the trial because it was worth doing in that situation. And then he ended up getting a way better sentence as a result. Didn't actually have to go to jail at all. This is the kind of analysis that you and your lawyer have to go through. It's not so much about what are your chances of winning per se. It's also about, well, does this accurately reflect the things that I'm giving up in exchange? If I don't take it and I go to trial and I lose, what do I think I'm likely to get? And if that answer is something same or similar to what I'm being offered, maybe you might as well go to trial. And if that's the position, then it's time to push back against the DA and maybe fight for something better. Thanks, and stay safe out there.